Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who routinely geek out on our channel here, you know occasionally we'll go real deep geek. And I'll pull out some law review article, and we'll talk about what a law review article is in a moment, and we'll talk about the theories behind it. Now, when you go to law school, every law school has at least one. Many of them have multiple law reviews. They're journals which cover certain areas of the law, and getting published in law review is one of the most important tasks for a law professor. I have found an advanced publication of something coming out on the Stanford Law Review. It's a very interesting piece, and I want to spend a few minutes talking about it because we've actually already espoused some of this theory, but there's a lot more to digest here. So today, let's spend a few minutes and let's talk about how they want to deal with the fact that gun control was created from racism. Okay, so the article that I'm talking about today is from Professor Jacob D. Charles. He's of the Pepperdine School of Law. Now, it's to be published in the Stanford Law Review. The title of the article right now is On Sordid Sources in Second Amendment Litigation. And what the professor examines here is the fact that ever since Bruen was announced last summer, we are taking a deep dive into the very early origins of gun control legislation in the United States, and we are finding a shockingly common pattern woven throughout each and every one of those. What is that pattern? Well, it's one that we've talked about on this video, and this video, and this video, which is that, you know, if you go all the way back to about 1640, 1642 in Virginia and you just kind of run it forward from there, what you see is that dang near every single gun control piece of legislation that we ever passed, leading all the way up to and through the Civil War, was actually based on one criteria and one criteria only, and that was the color of the person's skin, their nationality, or religion, okay? That was it. Now, how a law professor would put this dilemma in a law review article would read like this. Second Amendment litigation provides a fruitful context for clarifying possible pathways to greater consistency in the doctrinal treatment of our checkered past. That is particularly true given the Supreme Court's recent mandate to use a novel history and tradition only legal test, and because race, guns, and the law have been inescapably bound together in American society since its inception. Or put out there for all of you English-speaking folks is, hey, there is a problem when we go back and look at the early, rich history of American gun control, which is that, all of it is actually based in racism. And as much as those who favor civilian disarmament would like us all to forget the dirty little truth about the creation of gun control legislation in America, the author here also points out these laws have been legally dead for more than a century, but recent Second Amendment litigation has resurrected them to relevance. In this context, the question of what courts, counsel, and commentators should do with these moribund laws takes on heightened importance. So what the good professor is talking about there is, can those who are advancing the agenda of civilian disarmament still use these horrific gun control laws to their advantage? And the answer here, in short, is he believes they can. And candidly, and this is going to be a controversial statement, but this brings us back to why this is important, because as we know, there is a huge case before the United States Supreme Court next term called United States v. Rahimi. Now, that is going to deal with whether or not federal law, which requires an individual to forfeit all rights and possession of firearms and concealed pistol licenses while they are under indictment for a violent crime, whether or not that law is actually constitutional. And the problem for the government, or so they think, is that they don't have any true historical analogs under the Bruen test to go back and say, hey, we do have a history and tradition of restricting firearms in this fashion. But the truth of the matter is they do have those laws. They have those laws predating the Declaration of Independence, okay? The problem for the United States government is that they have to acknowledge, because it's the only purpose of any of these laws, that all of these were based in abject racism. Now, the professor points out that those who are actually advancing the cause of what is supposed to be inalienable rights has used these laws' horrific past to their advantage. As he put it, because the test requires past precedent for modern regulations, it renders novel laws invalid and thus puts enormous pressure on the search for any comparable analog in the country's historical tradition. One controversial way that public officials have responded to this test is by reanimating the sordid skeletons in our less equal past. But this is where the professor goes with it, and I actually tend to agree with this part, because when we take a look at is there a historical analog that could justify the types of statutes that are being questioned in Rahimi, the answer, in my opinion, is yes, there is. In fact, there is a rich, long history in the United States of government disarming classes of individuals that they deemed to be dangerous. And so if the actual thing we're looking for, the historical analog is has we as a society accepted the disarmament of certain population groups because we deem them to be dangerous to society, the answer to that question is there most unquestionably is. As a matter of fact, there probably is no richer tradition in American gun law than doing exactly that. And what the professor points out is listen, anybody who's tackling these laws really has one of three options. Number one, you can embrace them. Now, that is not a particularly wise move, both legally and politically, because to embrace laws that were clearly meant to suppress the rights of certain ethnic groups, it is clear that going ahead and embracing these laws and saying, hey, this is exactly the tradition that we should be justifying new laws on is pretty risky. Now, the other thing, of course, you can do is you can just renounce them altogether and say that, well, these laws have absolutely no bearing. They should not be considered in any way, shape, or form because of their racist past. Now, those who favor cancel culture, one would think that would be the automatic knee-jerk reaction to that, but no, that's not what they do. And the truth is if we are going to take a look at our historical analogs, we do have to go back, we have to take a look at American history, and yes, for anyone who's actually spent time and objectively studied American history, there are some pretty ugly chapters in that book. That being said, though, here's the issue, because instead of embrace, or instead of renounce, what we can do is we can abstract from it. And what that means is we can pull out the ideas which are historically analogous to what we're talking about in current law without having to get into the means for which the laws were passed. As the author put it, another approach could be called abstraction approach. Using this approach, the lawyer or judge would condemn the historical application of these laws, but abstract from their specific application a broader principle that might be applied consistently with contemporary values and understanding. And so if you take that and you apply that to what's going on in Rahimi here, is there a rich and historical tradition of disarming certain segments of population? There most certainly is. The difference between all the laws, however, that we cited, which were clearly done for racial purposes, is that the law here for Rahimi is actually doing that based upon Rahimi's actual alleged conduct. And I am not alone in this way of thinking. Justice Amy Coney Barrett, in her concurring opinion last summer in Bruen, specifically stated, history shows the Second Amendment permits disarming dangerous people. Throughout English and early American history, lawmakers passed legislation adapted to the fears and threats of that time and place. The founding era legislatures categorically disarmed groups when they judged them to be a threat to public safety. And so while there are many people who believe that United States v. Rahimi is going to yet be another huge win and a huge advancement in Second Amendment liberties, the truth of the matter is that this case, from a historical analog point, when we apply the proper Bruen analysis, it is in a far different position than many of the other cases we've previously have talked about. All the court needs to do is apply this abstract analysis to believe that the historical analog needs to have a similar purpose for similar reasons, but in its actual application may be laid out differently due to a modernization of how we view things. The bottom line is we have traditionally disarmed citizens that we believe to be dangerous. Whether that's right or wrong, that's open for debate, but the history of doing it goes way back, predating not only the Constitution, but even the Declaration of Independence. What's different about it today is that today Mr. Rahimi is being disarmed for alleged actual and objective conduct, that there are standards by which we can judge. It has nothing to do with his last name. It has nothing to do with the color of his skin, and it has nothing to do with what religion he practices. But it has everything to do with how Mr. Rahimi has behaved while a member of society. But as Professor Charles states in this law review article, and I tend to agree with it, but their unconstitutionality, to say nothing of their stereotyping and subjugating nature, did not render these laws useless for historical archaeology. If the past is to be a clue to the constitutionality of gun laws today, Justice Barrett's abstraction approach suggests that these laws can provide hints about earlier generations' understanding of legislative power divorced from their concrete application to specific groups. Put another way, judges and lawyers can use the principle without embracing the application. Listen, we're going to go ahead and link up the law review article right down there below so that you can geek out on it before. We're going to do more videos about United States v. Rahimi as it becomes closer and closer to the time of arguments. This case is actually much bigger than you may believe, and actually there may be another plaintiff adding on to it, which may bring a whole different set of facts into it, which may really expand the potential scope of this ruling. Listen, if you got any other questions about this or anything else, which might be related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now, but if you don't, that's okay. That information is right down there in the description box. Now, in the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From Washington's nicest indoor shooting range, that being Security Gun Club, thanks for watching. Stay safe.